Warm welcome from the heart of Munich at Privacy Café, where today's topic of discussion is data protection in the franchise network. There are many sectors, such as opticians, restaurants, organized as franchise chains, and today we want to briefly highlight in this article the data protection framework that needs to be considered in the relationship between the franchisor and franchisee. In a franchise network, the franchisor and franchisee establish a franchise agreement by entering into a franchise contract. In this, the relationship of mutual performance between the parties is regulated accordingly. At its core, it's about being able to operate under a common brand by granting license rights. Let's examine the legal framework for data protection, where the design of the franchise contract is of utmost importance. For instance, in the case where it is agreed that the franchisee must utilize certain IT systems provided by the franchisor. It could be a situation involving order processing, in which the franchisor assumes the role of data processor for the franchisee. This arrangement must be properly documented in a distinct data protection agreement as stipulated in Article 28. In terms of operational implementation, such as the advertising measures taken by the franchisee, it is typically the franchisee who bears the responsibility for their own advertising efforts. Therefore, the franchisor has nothing to do with that. It is also possible for the franchisor and franchisee to agree to engage in joint advertising activities, in which case a corresponding arrangement as a joint responsible entity is conceivable. Thus, it is evident that the franchise relationship has the potential to give rise to diverse data protection conditions, which are contingent upon the manner in which the performance relationship is organized and the identity of the party responsible for data collection and market presence. To quote Goethe, "He who does nothing for others does nothing for himself." And with that, to the conclusion. In the franchise contract, the processing relationship between the franchisor and franchisee should be regulated in as much detail as possible. It is possible to choose different data protection design options in a franchise contract. For instance, if the franchisee outsources data processing subject to instructions to the franchisor, or if they jointly or separately carry out advertising measures in corresponding responsibility, it can be considered likely. In addition, it is important to consider incorporating minimum standards for franchisees in the franchise contract, particularly in the areas of data protection and information security. What else in data protection? On the occasion of this year's autumn conference, the BvD has published a recommended press release stating that data protection should not become an end in itself. Link in the description. Enjoy reading.